versus societal good, re-examining corporate purpose under the Indian corporate law in the stakeholder era. Milton Friedman very famously said that the business of business is business. Yet, the contemporary legal discourse increasingly challenges this view, urging us to reconsider the corporation as a social institution embedded within a wider ecosystem. I now have the privilege of introducing Advocate Elizabeth Sheshadri ma'am, Advocate of the Madras High Court, who will be joining us as the moderator for this panel discussion. And we now have our panelists for today, the top three winners of the essay writing competition, Mr. Sharavind R., Mr. Ashwath Dinakaran, and Ms. Subiksha. Hand it over to you, ma'am.
Okay. Good morning, everybody. It's always lovely to be on a young people's campus. Takes 10, 15 years of us. So it's absolutely thrilling to be here. Welcome to Sharavin, Ashwath, and Subiksha, particularly because they are the prize winners of the essay competition that we conducted. And the topic, when we announced the topic, we were a little hesitant. Is this something that law students will be able to engage with? But I read all their essays, and the quality of their essays are so superior that I'm amazed. And I'm so impressed that they've engaged with the subject in a manner where they've given so much thought to it, that they're able to engage with these ideas in the future. And this topic is one of the most pressing discussions in contemporary corporate law. As Mariam was saying, we all grew up with the idea, Friedman's idea, that the business of business is business. The role of a corporation is to make money, make value for its shareholders, its owners. That's what Friedman said. That's what the Delaware courts held. That's what business schools taught. But today we live in an era where mandatorily corporations are being asked to do corporate social responsibility. Corporations are being asked to look at diversity. Corporations are being questioned on their governance. India was is the first country to actually put it down in a statute. The EU in 2023 has come out with directives that make companies civilly liable for human rights violations in their supply chains. It could be in the other part of the world. In the US, in 2019, we had some of the uh, the big corporate chaps sit down on a business roundtable and declare that shareholder primacy will no longer be the way they take things forward. They will look at other stakeholders. It's in this era that we need to discuss these issues of shareholder primacy, stakeholders, keeping risk appetite going, keeping enterprise spirit going. And that's what this panel is to. What we are really arguing about underneath all this legal doctrine and regulatory frameworks is something very ancient and undeserved, actually, which is the relationship between private power and public operation. If a company makes strong profits but does massive environmental pollution, has it served its public purpose? If it's simply from the very good thing. So our panelists today are law students who have engaged with the subject. So they have enough knowledge, they have made up their mind, and they have enough in them to be open to persuasion. We will move through three broad areas: the theoretical foundations of corporate purpose, the architecture of legal protection for these so-called stakeholders, and a broader question on whether doing good, just being good, and doing well, that is successful, are these compatible? So, Sharon, I'm going to start with you. Congratulations, you also the first prize anyway. Friedman said, business maximize profits for its shareholders. Friedman came along and said, no, business must look after other stakeholders, must look after workers, must look after employees, must look after environment. How do you see these two ideas play out in the corporate space? Will the answer change depending on whether you're looking at it from the market or whether you're looking at the law?
Sure. Ma'am, primarily, on my view, the corporates are working with they the resources they get are all from the public and the employees, the communities, and the environment. These are all the stuffs. They are utilizing these stuffs to earn profit. In that case, on gaining more profits, these shareholders to do some benefits in return to the stakeholders. Absolutely, in case if stakeholders are not good enough to get them such profits, they can't survive in the market. So the if the shareholders consider these stakeholders, both stakeholders as well as the shareholders, or on a broader scale, the country as a whole can develop.
I think you're articulating a point that looking at stakeholders actually increases shareholders' value. That's the hypothesis you're making. It says when you take care of your employees, when you take care of, including the statute says community, etc., your shareholder value will increase.
Yes.
You're connecting the two as necessarily a true proposition that shareholder value will increase. To place, I mean, just mention the other yesterday there was a news article about in New York's Mayor Mamdani has spoken up on behalf of 4,000 people, I mean, on behalf of labor, when Warner Brothers has announced a merger between Warner Brothers and Paramount Pictures. So there's a merger which will make a larger corporation, a larger conglomerate. It will be a more profitable enterprise, but 4,000 people are going to lose their jobs. And Mayor Mamdani has articulated this as an idea, saying that's not done. There is an effect which will, your profits will increase, but you need to look after the labor as well. So does it really, I mean, it's a question that we need to ask ourselves, and I'm going to ask you, Sudiksha, is there a problem for us to articulate this, that increased profits doesn't always, looking after stakeholder interest does not necessarily increase profits? They can be two different ideas. Is it intellectual cowardice for it's about shareholders' rights? Shareholders may have a say, transparency will help, but stakeholders don't have a right to influence the decision on the board. Which is why, I mean, that was a strong position that you had taken, and that was a previous position that we all, it was in the time that we grew up. Uh, in a sense, it seems a bit like intellectual, I don't know, we're just playing games. It's a bit of greenwashing. Do you think that we keep trying to say that looking after stakeholders means that shareholder value will necessarily increase? This is what you were writing about.
I actually believe in shareholders' primacy than the stakeholder. So, as we know in German model, it emphasizes that shareholder can block those decisions, but a stakeholder doesn't have the power to do so. I may guess, and according to my perspective, it is right. The shareholder should have the supreme value in their.
Because ultimately risk is being taken by the shareholder. That was your argument, yes. Ashwath, I'm coming to you. You examined the UK enlightened shareholders, enlightened shareholder value, where the UK model says shareholders are I mean, a board must act in interest of shareholders primarily, and also look at, in the process, stakeholders, which is different from ours, where we put them at par. The Indian model puts shareholders, stakeholders, community, employees, everybody at par. I would dread to be a director in this scenario because I really don't know whose interests I am to look at. Yeah. So have you compared the UK model with the Indian model in philosophically? Do you think that makes it clearer for a director in terms of how to function?
Absolutely, ma'am. I think I'm with you on that. Now, if we look at UK's Companies Act, and if we take section 172 of it, they have established a chain of hierarchy in that provision. And that is exactly why I call our Indian companies at Section 166 as a Trojan horse. Because we, for the sake of it, have we speak the language of stakeholderism while we act in the operation of of a shareholder at the end of the day. Now, if we look at it, I think in that way, UK has taken a far better stance. And I think it's time that we break the myth that ESG is no longer a fairy tale in India. Now, the real illusion lies with the fact that most of the Indian companies think that social good and profit are two enemies to one another. And if we go on to emphasize, are we to blame ESGs? No. Is ESG the problem? No. Are companies the problem? No. The real problem apparently lies with the way we have designed the Indian Companies Act. To be precise, Section 166. Now, on paper, if we take Section 166 subsection 2, by the Companies Act 2013, and I'm stressing on 2013, shareholder loses some amount of profits. Now, at the same time, the company polluted. Now, one person loses profits and the other person loses his means to livelihood because that river was the source of water. Now, if we lay on to call this a trade-off, it is equivalent to us comparing headache with a heart attack. And that, I think, is problematic. And that is exactly where enforcement has to come, and it cannot be a trade-off. Yes, ESGs on the longer run, of course, emphasize competitiveness, but it has to be real, it has to be enforceable, and not just good English in a statute.
Yeah, so you're saying that implementation has not been taken care of. We have something that looks great on paper. We have stakeholders being shown off as being part of the process, but are not really considered. Stakeholders at this point of time move public interest litigations. There's other avenues by which they go to court. We are now talking about why is responsibility being put on a company to look at issues of that kind, environment, etc., which normally would be what the government would be looking at. Now you're making directors liable for not looking at issues like that. And that's where I want to ask you, Michael Porter's hypothesis, where he says that looking at issues like environment actually drive innovation. It helps a company because it drives innovation and ultimately enhances competitiveness, which is the basis on which your argument is made. They always cite Germany's industrial sector, or they cite Denmark's move to wind energy, Japan's clean car fuel because it was higher stringent standards. But critics say that this is confusing correlation and causation, that Germany became what it was despite regulation and not because of it. I'd like you to just think about that also in terms of on whom do we place what responsibility? So the point when 10 people get together, say, I want to form private enterprise, I want to put in risk capital, and I want to move things forward, create jobs, employment. How much do you burden a private enterprise with regulatory frameworks on responsibilities about taking care of society? That's the idea that I'd like you to think about also. In fact, in that context, I want to ask you, Ashwat, uh, if you were looking at it from a developed country point of view versus a developing country point of view, because developed countries, they built their industrial wealth in a time when there was minimal environmental regulation. There was low labor standards, no mandatory social obligations. And now they impose high standards on developing countries and corporations, talking about green standards, investor funds put pressure, etc. They talk of supply chain obligations, saying your carpets are using child labor here, etc. Now, is this legitimate convergence towards a global standard, or is it a new form of regulatory imperialism that pulls up the ladder after they have climbed? That's another aspect that, as youngsters, it would be nice if you all think about it, if you have any comments on that.
I think I'd answer that question in a twofold manner. The first question is one with pertaining to Porter's thesis, and the second one is with regards to developed nations and enforcing obligations on growing countries like us. Now, if we go to Porter's thesis, I believe both the statements are partly true, but at the same time, they seem to be speaking ahead of each other as well. Now, if we look at it, ma'am, Porter's thesis by itself all the more means that regulation should drive innovation. And meanwhile, critics shall all the more argue that successful countries are able to afford regulation. Both statements are true. I'm totally with you on that. But here's where I would step in. When it comes to this regulation as a matter, the entire purpose of regulation by itself is to not achieve excellence. The purpose of regulation is to remove any scope for or any room for an excuse for inefficiency. Now, let's take a classic example, which I've even mentioned in my paper, the Tuticorin and Sterlite incident. Now, the people of Toothukudi, I guess all of us would have been aware of the Vedanta Limited judgment by the Supreme Court. Now, for almost 20 years, these people were suffering because of environmental violations done by the company. People protested, people died, and eventually the company was shut down. And the Supreme Court intervened under environmental law, under company law silence, dead silence. And that is very concerning by itself. And the reason why I say this is again because of selective enforcement. Under your section 245, it is only, of course, the shareholders would be able to file a petition, a class action suit before the NCLT for their failure of duties, but not the community. The same community which you included in your section 166 by itself, and all the more remarked on the later period. And all the more remarked on the later period that they'll not be able to come out. So I present you the legal irony present here. The director has to act in best interest of the community, but the community cannot even knock on the doors of NCLT if they fail in their duties. How does this even work? And that by itself is very, very concerning. I'm telling you, ESG framework in India is so polite that nobody is disturbed by it, including the violators. And that is very concerning. And the second fold of your question, ma'am, which is with developed countries pushing their notions on us, I think there is some amount of truth to that idea. But again,
activities, you will be penalized.
Actually,
The idea of, I think it's what Arvind was saying was, it is a visionary idea. The idea of telling corporates, why? Because the whole entity, a corporate entity comes because society has conferred on you the idea of a legal entity. It has conferred on you perpetual succession. It has conferred on you legal identity to enter into contracts, to hold property, etc. So in return, somewhere we formulated an idea that in return, society can ask you to bear a bit of the burden, which is what you have also argued, saying, yes, therefore we all become stakeholders to the way a company functions, but it's token, was your argument.
as you said, CSR under section 165, if a company earns a certain amount of profit, 2% of the profit to be used as corporate social responsibility, which under Schedule 7, which enumerates certain duties that can be done under that 2% net profit. But I look this, as you said, tax like stance, because when a company does some harmful things to the society, but instead of curing those harmful things, the company, just by paying certain amount of the profit to the society in a very different way, like um, say if a company pollutes a rivers, but instead they gain so much profit, out of that net profit only a 2% of that profit is used as building toilets, renovating schools. This is totally a in two different way, that in one way the company pollutes the river and gains more profit, and out of that profit a 2% of it is used for renovating a building or some other acts, said the society is benefited.
I'm going to just push a little bit, Sharvin. I want all of you all to think about beyond pollution, something we're all struggling to understand today, AI. So the other day we heard about Oracle, 12,000 employees lost their jobs overnight. Early morning email, you're out. 12,000, that's a huge number in Hyderabad. In the tech industry, we're seeing quite a bit of fear of unemployment, imminent unemployment. And sometimes I wonder if, if these companies let go of employees and their ways of earning money, who's going to consume these products which they're going to increase in making, etc. So it's in this context also a sense of social responsibility. Like you say, companies think they're going to make huge profits using AI, reducing their labor burden, and you're asked to pay 2%, etc. Is there we have to think in terms of, can we use law as an instrument to impose a burden on them that jobs cannot go, that whatever technology changes come? I don't know. I'm just thinking aloud. I know we don't have answers. I don't want us to have answers immediately. It isn't meant to be answered in this panel. But it's something to be thought about. How do you impose? Like we say, our trade-off is 2% versus what? So if profits will increase largely with a large segment of their employees being left out, what kind of government intervention can we talk about, if at all? Subiksha, you were looking at the co-determination model, the German co-determination model. And it's worked. For instance, so in Manesar, the Maruti, one of our successful companies, Maruti Labor, has been struggling and fighting at Manesar for so long. Over a period of time, we have weakened our labor unions. We were a country with strong trade union history. We have weakened our labor unions, and today we call them stakeholders. If corporations genuinely are to look after their stakeholders, including labor and employees, why do we not give employees, communities, environmental groups, etc., seats on the corporate boards as a matter of law?
as Germany does in its co-determination model. You have in your paper talked about it, and you please let us know what you were saying about the transparency model. That was an interesting model. You were not in favor of giving them a seat at the table, but you said we must facilitate other things for them. So why don't you explain that to us?
Actually, about my perspective, India, we have to initiate that model. It helps a lot of stakeholder. Essentially, the one most important thing, they can able to have the seat in the board for supervision. But according to me, they can't suit a file against the director personally. Other than that, the transparency model by having a seat in that supervision will work for them.
So you mean to say they must be kept informed of decisions which will influence them. For instance, Warner Brothers merger, they must announce that X number of jobs will be lost so that the trade union can agitate in the right forum. However, directors or boards must not be made responsible for those decisions. Yeah, that's an interesting perspective. So you're articulating saying, give them information, give them seat at the table to negotiate, but not at the decision-making table. Decision ultimately is for the owners and shareholders only, which is the earlier shareholder primacy regime. Okay. I'm going to close with one question. If you have to choose between a corporate law framework that maximizes economic growth and one that maximizes social justice, which one would you choose? And I'll give you don't think you have to give a yes or no answer or this or that answer. In fact, a lot of this topic stuff is in the nuances.
I think the answer to the question lies in the question by itself. Thank you so much for the hint at the end. I'd say, as you said, it's not really a direct yes or no. Of course, the business has to the business is to business. So of course there has to be profit maximization. Of course they'll have to. But all we're saying is, as even Subiksha said, if we just resort themselves towards transparency alone, it is a little hard for us. I think transparency without accountability is nothing. Now, even when we talk of giving them a seat at the table, apart from just being for participation, if we even take National Textile Workers Union judgment, where Justice P. N. Bhagwati would have all the more gone in and said that when you wind up a company, the employees have to be given the right to be heard. And it was not just a seat at the table. They said that there is a mandatory duty for the company to not just have some amount of obligation towards the creditors or the depositors alone, but again, the community, the workers and all. And that is exactly where I think we'd have to strike a balance. So I think the only way to go about this would be to ensure that, well, focus on profit maximization. At the same time, don't leave society. As there's a common proverb in Tamil which goes, "Alavukku meerinal amrutamum nanju." So I don't think we shouldn't go at the absolute speed of profit maximization and not care about the society or other evils. I think we just have to account other factors as well.
That's also a good point of time to think of our Bhopal gas victims, who till today probably are still struggling for their compensation, and nobody's gone to jail. Nobody's gone to jail with the deficiencies in the way they conducted corporate governance at that point of time. Sharvin, do you want to say something on this?
I agree with what Ashwat said, that the purpose of a company and a business is to business. So
So we'll wind up very shortly, sir, in a minute.
that their primary motive should be profit earning, but they should not leave behind the society.
Yeah, I think we will conclude with that. Thank you so much. I think one of the things that has come out is, yeah, so we have a shareholder primacy model. We're all in agreement that we can't simply function on, you know, go full steam ahead thinking only shareholder primacy. But there is, and happily, no agreement in terms of what the prescription for this is. We talk of stakeholders, but like you said, it's on paper. We've got no process in terms of how stakeholders enforce rights. We don't have a process in terms of how stakeholders get to know what's happening. So there is that issue. And the good thing about this conversation is we are not meant to have that answer yet. See, the students here are the ones who will be future policymakers, lawyers, judges, etc. And you will engage with the subject. This conversation, I hope, has just made it harder for us to just give an easy, flippant answer. To say that profit maximization is what what the job of a company is simply, or to say that societal good doesn't work well with profit maximization, or to think that ESG norms, etc., will make us function better, or to say that looking after stakeholders will bring better value to shareholders. These are easy answers because they've been tried over the years. What we now need to figure out is a model where we know in India, we have a social justice issue. We know we need the economy to move faster. We know we need jobs and employment. And we know we also have the Narayana Murtis who will say that 70 hours of work is what you need to give us. Issues of mental health, privacy, all those issues are there. We need to figure out the answer to this. And thank you so much for engaging with this, to you and to all the other participants of the essay competition who have engaged with this topic, which in contemporary corporate law is one of the most pressing discussions of the day. Thank you so much to the panelists. We will hand over to, for the reason for which we are all here, to hear Justice Sundar. Mariam?
Thank you so much, ma'am, and all our awardees for today. Thank you so much for that session. I'm pretty sure they were put to test. They submitted in writing, and ma'am, we badgered them to, like, make sure what they put into writing is exactly what they believe in and is something they can defend. I would like to thank ma'am and the awardees again. We will now proceed with a formal commencement of the endowment lecture. Once again, good morning, everyone. Distinguished members of the judiciary, the legal fraternity, esteemed faculty members, honored guests, and my dear participants and members of the audience. My name is Mariam Amin, and I will be the master of ceremonies on this occasion. It is both a privilege and profound honor to welcome all of you to the C. Harikrishnan Memorial Endowment Lecture, an occasion that stands at the intersection of remembrance and intellectual pursuit. We are gathered here today not merely to host a lecture, but to continue a legacy. As Justice Benjamin Cardozo once observed, the final cause of law is the welfare of society. It is in that spirit that we come together today to reflect upon the law not as a static construct, but as a living, evolving discipline shaped by thought, dialogue, and experience. Today's lecture commemorates the life and legacy of Sri C. Harikrishnan sir, an advocate, a scholar, a mentor whose contributions to company law and legal education continues to resonate across generations. His life reminds us that the practice of law is not merely a profession, but a sustained commitment to intellectual rigor and public purpose. We will now proceed with a formal invocation, a tribute to the cultural and intellectual heritage that grounds our pursuit of knowledge. Before we begin, may I please request the dignitaries of today to please make your way to the dais. May I request everyone to please stand up for the Tamil Taiwan.
நீராறும் கடலொடுக்க நிலமடந்தை எழிலொழுகும் சீராரும் பகனவென திகழ்வரத கண்டவித்தில் தெக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிலமை திறம்பியந்து செயல் மறந்து வாழ்த்ததுமே வாழ்த்ததுமே வாழ்த்ததுமே.
Thank you, everyone. I have the pleasure of introducing to this crowd Professor Dr. Ranjit Umin Abraham, Director of the School of Excellence in Law. Sir's leadership continues to shape this institution into a space of rigorous leadership and academic distinction. To formally welcome this distinguished gathering, I kindly and humbly request Sir to please deliver the welcome address.
A very good morning to the dignitaries on the dais, off the dais, my colleagues and my students, and all the other participants for this endowment lecture. It instills great privilege on me to stand here on this very important day, auspicious day, where we have a very eminent personality to deliver the Harikrishnan Endowment lecture. I am standing here on behalf of my dean, who's supposed to do the welcome address, but he has to sign an MOU with the FASI, that is the Intellectual Property Association of South India. So he couldn't come, and he has sent his wishes and requested me to give the welcome address. And I'm sure that we are little out of time, slightly. So, and I'm sure all of you are come here on this Saturday, that too a day in between so many holidays, just for one reason, to hear Justice M. Sundar. So I will not stand, give you a long welcome, but I will welcome the gathering as short as possible so that we can use more time to hear and get ourselves enriched in the wisdom which could flow from the words of our Honorable Justice M. Sundar on the topic of corporate law, which he is going to deliberate today. Firstly, when you all know that we have all come here for this Harikrishnan Endowment lecture. Advocate Harikrishnan is a very senior corporate lawyer in Madras High Court. Karthik sir will be talking little more on about his father, so I not do much, but he's a very famous corporate lawyer. And also, we academicians should be very proud that he was also an academician. He was a teacher for many professors. He was a teacher for many advocates, senior advocates, and he was also a teacher for many judges. And if I'm right, the former Chief Justice of India, Sadasivam, also was his student, because the first lecture, Harikrishnan Endowment lecture, was given by the then Chief Justice of India, Justice P. Sadasivam. And after that, there was a small gap due to administrative reasons. We were shifting our campus, and we couldn't connect with Karthik Sheshadri or the law firm, which is supposed to join us and conduct it. Better late than never. We have started now, and we were discussing about the guest, and Karthik Sheshadri sir immediately told that the best person to talk about this is Justice M. Sundar, and let me try to reach out to see and find out when Lordship can come. So we said, if Lordship is coming, whether it's Saturday or Sunday, whether it's summer vacation, we will have it, because it is a great privilege to hear Lordship speaking, because I am personally a fan of Lordship's speech. In many occasions, Lordship has come here to this university and spoke on moot court, on inaugurating moot courts, on judging moot courts. Also, Lordship has come here last year and gave a wonderful graduation day address to the graduates of the School of Excellence in Law. where he was able to, inspire by some of the stories, which was really part and parcel of his life, which brought him to the elevation of a judge, that to a successful judge, and presently the Chief Justice of Manipur High Court. And we assure Lordship that we will be hearing more and more good news regarding your status in the judiciary, and we are waiting for that. And we, in the academics, we are very sure that you will be continually contributing to the academics by coming in spite of your busy schedule wherever you are. And coming all the way from Manipur is something great, because you know that judges are all very busy, and calling them from, the Chennai Madras High Court itself is a challenge for us to bring them here to Taramani. Lordship has come all the way from Manipur. So I request the gathering to give one of the best and loud applause for Lordship for having come. I also take this as a very important occasion for, welcoming the other judges who are here. Two of them, they decided not to come to the stage in spite of their status as a judge. Justice Basha. Justice Basha retired from Madras High Court. Subsequently, many of you know that he has contributed a lot to the intellectual property jurisprudence by being the chairperson of IPAB, and a highly knowledgeable judge. I can only tell one small instance, though it's little out of the way. Once I went to invite Justice Basha in his chamber. This was something from 17 years before, I think, Lordship. And you won't remember that. So I wanted Lordship to come for a moot court competition, and I told Lordship, please come. He immediately said, you are a professor. I'll ask you 3 questions. If you can answer at least 2, then I will come. If you don't answer minimum 2 questions, I will not come. And I was really surprised, because none of the judges given that kind of a challenge to me. And luckily, he asked me on cyber law. The first 2 questions were on cyber law, which is a subject which I teach. So I was able to answer that. The third question was out of some other subject which I don't know. And so because I got 2 out of 3, I scored 2 out of 3, Lordship had to come for that moot court. But that moot court was conducted in Sriperumbudur, not in Chennai. So Lordship came all the way to Sriperumbudur with his brother Judge Justice Nagamuthu. And that day, was an excellent day for us. Organizing a moot court somewhere else, Tamil Nadu Ambedkar Law University, Chennai, organizing a moot court somewhere else. So thanks a lot, Lordship, for coming today. I know you are a great academician also, helping the academic. Justice Sendil Kumar has also come here, and we are very happy that you are here. We welcome you, Lordship, for this lecture. And it's something great to have a High Court judge to come and attend this lecture. It's something great, Lordship. Thanks a lot. I have to welcome my convener, Justice Bharati Dasan. And some of you are from not from School of Excellence here. So I'm just to tell you that presently we don't have a Vice Chancellor. So we have a Vice Chancellor committee, convener committee. The convener is Justice Bharati Dasan, nominated by the syndicate. For the past 1 year, our university is doing so many academic programs, and we are able to achieve a lot in the last 1 year. In fact, our Moot Court Association students, they have won more than 60 national moot court competitions and around 4 or 5 international moot court competitions. Even though we don't have a Vice Chancellor, but we have something 10 times more than a Vice Chancellor here, sitting here. So Lordship is always very keen in knowing what is happening, and he's also encouraging us from left to right. And he's also telling us to achieve more and more. And moreover, even though he was a judge of the High Court, presently the chairman of the Tamil Nadu Backward Class Commission and chairman in many other committees, very important committees, Lordship is very, very humble. He is accessible not only to the teachers, but he is accessible to the students. And that is a challenge for teachers, because when we don't do anything, immediately the complaint goes to Lordship. But he very carefully, tactfully, he will not put us down also, but he'll encourage us to meet the challenges of tomorrow, because we are all here to serve the younger generation. I welcome you, Lordship, for this gathering. In spite of a busy schedule in the afternoon, Lordship has to travel. He said he will join and he will bless us. My Next welcome goes to Senior Advocate Shankar Narayanan sir, and he's a former Additional Solicitor General, Government of India, a very, very prominent lawyer. At the same time, I know sir for a long time. In fact, he has also been supporting us in motto in various aspects of academic venture. He is used to always tell us that whatever you need, you please come to me. I will do the needful. I welcome you, sir. I think I need not welcome Karthik and Elizabeth, ma'am, because this program is part and parcel of us. But at the same time, as all of you should know, Karthik sir is the son of Senior Advocate Harikrishnan sir, in whose name this endowment lecture is there. And recently, as we renewed our relationship, our university renewed the relationship with their law firm so that we can have this program every year. Karthik sir promised 2-3 things to us. One is he promised that every year he will bring the right person to address you in this endowment lecture. The second promise, what Karthik sir told us, is that he will conduct an essay competition every year in the subject of corporate law. So in line with this endowment lecture, and so that he'll encourage the younger students to participate and learn corporate law. And third thing, he said that his law firm will regularly be used, that is Karthik sir, Elizabeth ma'am, and all the other members of his law firm, Iyer and Thomas, will be can be used by our law school to conduct lot of programs in corporate law, special lectures in corporate law. And he has also promised internships and placements from the School of Excellence in Law. So it's a package which we got. So thanks a lot. I welcome Karthik sir. I welcome Elizabeth ma'am. She's a very great speaker, and I know her before I could know Karthik sir because she has been regularly earlier taking some classes in jurisprudence, in professional ethics. She was a member of the International Bar Association of Professional Ethics, and so on. I welcome all the other gathering, the members of the Iyer and Thomas law firm, the family members, our teachers, the head of the departments, directors, all of them who have come here. For paucity of time, I'm not mentioning the name. My special welcome goes to all, especially those who I have not welcomed. Thank you.
Thank you so much, sir, for your very gracious welcome. We now move on to felicitating our distinguished guests this morning. I now humbly request Justice Bharati Dasan sir, Senior Advocate Shankar Narayan sir, and Advocate Karthik Sheshadri sir to kindly felicitate our chief guest of today, Honorable Justice M. Sundar sir, Chief Justice of the Manipur High Court. Your felicitations. We are felicitating His Lordship with a book, a bouquet, and a photo frame of the Madras High Court. I now request Advocate Karthik Sheshadri sir to present a small token of appreciation to Honorable Justice Bharati Dasan sir. Thank you so much, Your Lordship and guests. I now have the pleasure of introducing to this crowd, as Ranjit sir has already introduced before, Advocate Karthik Sheshadri sir, partner of Iyer and Thomas law firm. Sir is well known for his work in commercial disputes, arbitration matters, mergers and acquisitions, and many more varied fields of law. Every endowment carries not just a memory, but a meaning that drives that memory. To acquaint us with the life and legacy of Sri Harikrishnan sir, I find no better person to call other than his son, of course, Karthik Sheshadri, sir. And with that, I kindly request, sir, to please acquaint us with the life and legacy of the late Honorable Sri Harikrishnan, sir.
Good morning to all of you. Respected chief guests, Honorable Mr. Sundar, respected Justice V. Bharatidasan, former Judge of our High Court, respected Justice K.N. Bacha, Justice N. Chandra Kumar, the Dean who is present today, Dr. C.N. Ambedkar Law University, Dr. Balaji, Mr. Shankar Narayanan, former ASG of this of Union of India and a very, very dear associate of my late father, advocates present here, professors of the Dr. Dr. Ambedkar Law University, other dignitaries on and off the dais. The outset, I consider this an honor and privilege to briefly speak about the endowment that has been instituted. The idea to institute this endowment stemmed out of my late father's passion for teaching law. We created this endowment when he was 80 years. The then VC of the university was Professor Dr. V. Vijay Kumar. He was a student of my father and also happened to be my professor in the National Law School in Bangalore. He was delighted to receive this endowment. The inaugural lecture was delivered by Honorable Mr. Justice P. Sadasivam, the then Chief Justice of India and another illustrious student of my father. My father's passing in March 2019 and the subsequent intervention of COVID-19 changed our focus for a while. I'm very happy and extremely grateful to have the second lecture delivered by a scholarly, erudite, eminent jurist, Honorable Mr. Justice M. Sundar, Chief Justice of Manipur High Court, who has taken time out from his extremely busy schedule and from a very highly sensitive state, Manipur, to have come all over to address us all on today. Mr. Harikrishnan was not merely a practitioner. He was, by all accounts, a doyen of company law litigation and a teacher and a lawyer with impeccable integrity and intellectual honesty. His name continues to command deep respect in the field of company law and commercial litigation in Madras and outside. Please permit me to share two instances very recently that reflect the enduring regard for him. I recently met a senior judge who is now retired from Calcutta High Court at the Madras airport. In the course of our conversation, I mentioned today's event to him. The moment I referred to my father, he immediately recognized his name and spoke very warmly about him, recalling how his senior, Mr. Sudipto Sarkar from Calcutta, had often spoken very highly of their work together in several high-stake matters. Second, when we invited another learned judge who hails from Telangana, he responded instantly upon seeing the invitation. Mr. Harikrishnan, company lawyer. Oh, he went on to recall having watched my father argue numerous matters before the then company law board and expressed great admiration for his advocacy. The reactions we have received from several judges of our High Court who knew him have been strikingly consistent. He was remembered as a gentleman lawyer, courteous, kind, deeply knowledgeable, and always willing to help. Though most of Mr. Harikrishnan's field of practice was in company law, which is generally considered as a very elitist practice of area, he firmly believed that corporations were a collective trust for the benefit of shareholders, like small investors, workers, operational creditors. He was active as the secretary of the Shareholders Association, which was set up to foster the needs of several small investors. This endowment has been created with a clear and enduring purpose to foster continued engagement with these ideas of corporate law so that future generation of students and practitioners are able to appreciate these values. Another important feature of this endowment is the annual essay competition for students, which accompanies this memorial lecture. This initiative is particularly meaningful as it encourages young minds to engage critically with contemporary developments in commercial law. I believe that those who participated in the topic given this year will easily be able to face any interview with a top tier law firm once they pass out and would be in a position to impress them. Our endeavor is to get young minds ready for the outside world through academic engagements. In the last 10 to 12 years or so, we have witnessed an enormous change to the way commercial litigations have evolved. If we cast our minds back to years gone by, the shift we witness today is prolific and unrecognizable. As lawyers, we have had to adapt ourselves to relearning so many aspects of the law, the process involved, and the nature of the litigations that we are faced with. We are especially fortunate today that today's lecture will be delivered by Honorable Mr. Justice M. Sundar. When we considered potential speakers, his name emerged almost instinctively for his erudition and in-depth knowledge, inter alia in the area of commercial disputes. Throughout this period of transformation in commercial dispute resolution, Justice Sundar has been in the forefront. On the administrative side, Justice Sundar played a pivotal role in framing the rules of the Madras High Court governing proceedings under the Arbitration and Conciliation ANC Act, as well as in shaping the Intellectual Property Rights Division. During the COVID-19 pandemic, when courts across the country had to rapidly adapt, proceedings shifted to online filings and virtual hearings. These systems have since evolved and improved, and His Lordship's contributions, particularly as a member of the Information and Communication Technology Committee of the High Court, have been instrumental in their progress. On the judicial side, Justice Sundar has, through a series of significant decisions, shaped the contours of modern commercial litigation. His deep and nuanced engagement with the issues such as arbitrability, interim release, interference in awards under the ANC Act, and procedural discipline in commercial suits has brought clarity and coherence to the law. He set the stage for conditions for determining urgent interim reliefs to avoid pre-suit mediation in Vardhan versus Prakash Babu. You all are aware of that. He laid down tests to determine manifest intention to arbitrate before grant of interim reliefs under the ANC Act. Personally, appearing before Justice Sundar has always been both a privilege and a challenge. While testing awards, he was particular about the pigeonhole of the challenge. His command over the latest jurisprudence is extraordinary. I must candidly confess that there have been occasions when I have had to seek His Lordship's indulgence for not having had the opportunity to read a judgment delivered barely a day earlier, one that His Lordship had already analyzed and was prepared to apply to the facts of my case. The sphere of intellectual property and commercial litigation, His Lordship's approach had come to represent the benchmark of both efficiency and exacting precision. During FIFA World Cup, His Lordship notably directed injunction of over 12,000 websites to curb the unlawful streaming of matches in the Viacom matter, an intervention that underscored both the scale of the challenge and the decisiveness of the response. His decisions consistently embody a careful calibration between urgency and fairness, coupled with a steadfast commitment to ensuring that procedural law remains a vehicle for substantive justice. We are deeply grateful to Justice Sundar for delivering this memorial lecture on the theme of transformation of commercial disputes. This occasion is not merely one of remembrance. It is a moment of renewal, an opportunity particularly for younger members of the bar and for the students of law to reconnect with the tradition of excellence that must endure even as the law continues to evolve. I would like to sincerely acknowledge the support of the Dean of the Dr.Ambedkar Law University, Professor Ranjit in particular, along with his team, for their efforts in organizing this event. Such an occasion is made possible only through significant work behind the scenes. I must place on record my gratitude to my colleagues, Charanya, Suraj, Rajaji, Janani, Jayadran, Kanishka, Sanjay, and Abhinav, and not least to my partner Elizabeth for their tireless efforts. The essay topic itself was a product of an internal office competition among our colleagues, and Sanjay had come up with this thought-provoking topic. I warmly invite all of you to engage with the ideas that we presented today. I hope that the students in particular will benefit from the insights of a distinguished jurist such as Justice Sundar and carry them forward in their professional journeys. Thank you so much.
Thank you so much for your words, sir. I now have the pleasure of speaking about Honorable Thiru Justice V. Bharathidasan, sir. His Lordship did his BL in Madras Law College and thereafter enrolled as an advocate in the year 1985. In the year 2005, His Lordship was appointed as the Senior Panel Counsel for the central government at the High Court and continued this post till 2015. His Lordship was also the Standing Counsel of the Chennai City Municipal Corporation and had extensive practice both at the principal bench and the Madurai bench of the Madras High Court. His Lordship was appointed as a permanent judge of the Madras High Court in 2016 and retired in the year 2025. At present, His Lordship serves as the chairman of the Tamil Nadu Backward Classes Commission. And as Ranjit sir mentioned, he also serves as a member of the convener committee here at the Tamil Nadu Dr.Ambedkar Law University. On that note, it is now my privilege to humbly invite Honorable Justice V. Bharathidasan sir to deliver the presidential address.
Honorable Mr. Justice Sundar, Chief Justice, Manipur High Court, Honorable Mr. Justice K.M. Pasha, Honorable Mr. Justice Endil Kumar, Honorable Mr. Shankar Narayanan, Senior Advocate, Former Additional Solicitor General, my dear friend Karthik, Elizabeth, my dear lawyers from Madras High Court, teaching faculty, students. Very good morning to all of you, and I welcome you all once again. Not going to pick up your time. Normally, this kind of lectures all will be due to the long holidays, election, and the upcoming exams. Most of the students could not attend the function today, so this list and apologies. Mr. Harikrishnan, Senior Advocate, whose name this endowment has been created for the university. We have 3 endowments. The name of the 3 the Arbitration and the Ragarapa, former advocate from the Sunmost. All the 3 of the endowments are functioning well. They are conducting lecture meetings here in the university. It's more beneficial to the young lawyers, students. So far as Mr. Harikrishnan is concerned, I know him personally well. He's a multifaceted personality, a great lawyer, good teacher. He's much interested in sports. I know him, a cricket lover. I used to have a small Manchester, watching that, hearing the commentaries about those days. A tennis player, I was told he's a good tennis player and a music lover, an artist also. He's a very fine gentleman. I know him very personally. I studied him in many cases in company law as well as in trademark case. The assisting is a very pleasure. You used to educate us. Of course, I don't know anything much about company law and the trademark. He asked me, call me, sit 3 hours, 4 hours, keeping and educate me. You should be this, you should see that, you should see this. You're not, even then he used to teach us. A nice gentleman. I'm very happy that Karthi and Elizabeth organized this lecture series, lecture meeting And the topic chosen is very important and relevant today. I think in the future, legal profession is only corporate, commercial law. In my estimate, my brother Basha and Sandikumar also accept that all the conventional cases slowly die down in the but yes, filing of suits are all now so much reduced. The future is only the corporate law. Now after the Commercial Court Act and establishment of commercial court, so far as Tamil Nadu is concerned, brother Mr. Sundar is instrumental. He has taken all initiative. Now all districts we have commercial court. All courts are functioning very well. All courts, I know, I have the information. All the courts are functioning well. So it is very apt that you have collected the topic today. I thank you once again. I welcome you all. Thank you. Thank you very much.
Thank you so much for the address, sir. We now arrive at the most anticipated segment of today's program. It is a matter of immense honor to welcome our chief guest of today, Honorable Thiru Justice M. Sundar, sir, Chief Justice of the High Court of Manipur. A few words about sir. His Lordship graduated from the Madras Law College and enrolled as an advocate in the year 1989 and had a wide spectrum of practice, primarily in the Madras High Court, besides his appearances in the Supreme Court and other high courts. His Lordship is known for having represented the IUML and the HRNC for over 2 decades simultaneously and was later elevated as a permanent judge of the Madras High Court on 5th October 2016 and was later sworn in as the 10th Chief Justice of the High Court of Manipur on 15th September 2025. His Lordship has graciously accepted our invitation and will be delivering the endowment lecture on the topic, the transformation of commercial dispute resolution in India, commercial courts, arbitration, and the role of corporate lawyers. On that note, may I humbly request sir to please deliver the endowment lecture.
Honorable Justice N. Sendil Kumar, Brother Judge, Judge of the Madras High Court, Honorable Justice K. N. Basha, former Judge of the Madras High Court, former Chairman of the IPAB, Intellectual Property Appellate Board, headquartered in Madras, Honorable Justice V. Bharathidasan, former Judge of the Madras High Court, who is now part of the Dr.Ambedkar Law University, Professor Ranjit, Shankar Narayanan, Senior Advocate and former Additional Solicitor General of Southern Zone, Mr. Karthik Seshadri, Elizabeth Seshadri. I find Mr. Sundareshwaran, Kokilavani, Mr. Rahul Balaji, advocates, and several other known faces. Pardon me for not mentioning each one by name, and pardon me if I have missed out on mentioning somebody here by name. And Mariam Amin, who did the comparing and gave the introduction. Most importantly, the students, law students who have gathered here, lawyers to be, judges to be, jurists to be, professors to be, maybe lawmakers to be, and most importantly, my fellow students of law. Good afternoon and greetings. Fellow students of law was an expression used by Nani Palkibala while addressing the convocation in Bombay University. In his case, it was out of humility. In my case, it is a matter of fact. It is a statement of truth. On this topic, it says the transformation of commercial dispute resolution in India, colon, commercial courts, comma, arbitration, and role of corporate lawyers. It is in 4 parts. I don't intend boring you with great details on each of these 4 parts. As I've been, Mr. Karthik Seshadri called me. I was wondering why me from Manipur. He did say he was kind enough to, it was more out of kindness and affection than out of truth. Very, very happy to be in your midst. I found 2 more connects. I have not had the privilege of interacting with Harikrishnan personally, but I have seen him argue in courts regularly, particularly in what we used to call the company courts those days. But what has been a revelation for me is from his life sketch, which is before you all, is one, he is from Myanmar. I am in Manipur, which shares the border with Myanmar. Probably one connect. 2, I am able to recollect that it was sometime way back in 1989 or 1990. He had his office in Moore Street. It was in an upper floor. As a young lawyer who had just enrolled, much before many of you were even thought of, I had gone to Harikrishnan's office to serve one notice on an operation and mismanagement matter, section 397, 399 of the Companies Act, erstwhile 1956 Companies Act, if my memory serves me right. And on coming to know that it is done by the clerk, on coming to know that it is a young junior who has come, he came out, received it, and made a polite conversation with me. I still very vividly remember that. And he received it himself. That was before he was designated. I double checked with Karthik Seshadri as to when, because I remember he pulling out the pen and receiving the notice. As a designated senior, he would have definitely not done that. So that's why I confirmed with him. He was designated after that. This was in 1990. And the other revelation is he's done refer trials. I never knew that he was on the criminal side too. Those days, the civil bar and the criminal side bar were clearly compartmentalized. So very rarely did we have somebody who was prolific in both sections of the bar. That was another revelation for me. On that note, I'm grateful that you have thought of me. It is my honor, pleasure, and privilege to be here. Starting on this commercial courts, I asked Mr. Karthik, how do you want me to go about it? Who are going to be the audience? He said, largely students. Then should I go on first principles? He said, no, it would be preferable if you're philosophic. and you talk about the philosophy. But I exercise my veto. And what I propose to do is neither make it completely esoteric and philosophic, nor make it first principles and make another classroom here. Definitely not pedagogy. Pardon me, Professor Rajit. It is not going to be another classroom for sure. I'll try to give you a blend of both, an esoteric part of this topic and some first principles which may be food for thought for all of you. This Commercial Courts and the Commercial Courts Act 2015 kicked in on 23/10/2015. It came in as an ordinance to start with, and then it became an act. We have borrowed heavily from England. Therefore, just give you a bird's eye view of what happened in England and how it came into existence in 2015 in India. I'll just take about 2 minutes on that. In England, up to 16th century, you had what is known as the law merchant. Law merchant was an independent system of justice which dealt with commercial causes. Sometime in 1774, the famous Wheeler's case. When I say Wheeler's case, there are many, many Wheeler's case. I'm talking about the 1774 Wheeler's case, which was on maritime insurance. I'm sure you may Google and check. So it is 1774. Many Wheeler's cases are there. Lord Mansfield made a very strong observation. He said, in commercial causes, you should be consistent and there should be a separate jurisdiction on separate courts. Thereafter, there was a lull for about 100 years. The wheel that Wheeler set in motion by Mansfield was reinvented in 1873. Lords Bowen and Matthew wrote to the then Chief Justice Coleridge saying we should have a separate commercial court for commercial causes. It was put to vote. This is a little important. It was carried by a 20:5 majority, but it did not take shape. The reason was Lord Coleridge was not in favor of it. I need something to say on that. Therefore, I'm touching upon this. A little later, sometime in 1894, nature overtook Lord Coleridge. He was no more. Lord Russell succeeded. And this time, the commercial court in London was established. And Lord Matthew himself was the first commercial court judge who presided the commercial court in London on 1st of March, 1895. This is how the commercial court came into existence in England. And later what happened, contemporary history most of you are aware of. Let's come to the Indian scenario. In India, sometime in 2003, the Law Commission gave a report, which is 188th report of the Law Commission. This is dated 15/12/2003. The Law Commission flagged one important issue. Indian companies are being dragged to American courts. Indian companies are being sued in American courts. And the American courts, with due deference to Committee of Law, Committee of Law across borders, we're still entertaining the suits on one ground. All this is there in the Law Commission report. On one ground. And that ground was, it takes not less than 10 years for a suit to conclude in India. This was flagged by the Law Commission in the 188th report. Then this gained momentum. A bill was introduced in the parliament. When it went to the Rajya Sabha, it was referred to a select committee. And the select committee, as it was examining, the bill lapsed. Subsequently, with the inputs and opinion of the select committee of the Rajya Sabha, the matter was referred to the Law Commission again. And this time, the Law Commission came up with the 253rd report. 253rd report is dated 29/1/2015. And this provided the platform for separate commercial courts, which came into existence on and from 23/10/2015. This Commercial Courts Act came in as an ordinance at that point of time. Now, pausing here for a moment, I mentioned that it was carried by a 20:5 majority in England, and Lord Coleridge was opposed to it. One of the criticism is, it's very important. Why do you think somebody would oppose a separate commercial court for commercial courts? What could be the opposition? Can any one of you think of it? I will make it a little andragogic. Any thoughts on that? Why would somebody oppose that? I will tell you, there might be a criticism as to why separate courts for commercial causes alone. Somebody might ask you, a 2.5 cents of homestead, a 2 cents of homestead, or 5 cents of farmland may be as dear and important for a litigant as it is for a litigant litigating for a 500 crore mark or a 500 crore brand. Why this distinction amongst litigants? This may be one criticism. The answer is, no doubt, every litigant has whatever his claim is very, very dear to him. And 2.5 cents of homestead or 5 cents of farmland can be as important as a 500 crore mark. But the point is this, the answer is threefold. One, as regards commercial courts, which is commercial division in the High Court and commercial appellate division in the High Court, they are exclusive commercial courts. They are dedicated commercial courts. For instance, in Tamil Nadu, we had 7 for sure. I don't know how many now. 2 in Madras, 2 in Salem, 2 in Coimbatore, and 2 in Kanchipuram. These are courts constituted exclusively. They do not overlap with the courts which deal with the traditional and conventional litigation. One. The second, I said it is threefold. 2 is, in areas where it is not an exclusive court and where it is only a designated court, let us have clarity that what Vivian Bose said in the oft-quoted Sheriff's case still holds the field. When a court deals with both criminal and civil law, the sessions matter are taken up first. The sessions matters are taken up first. Matters pertaining to custody, personal liberty are given priority. That continues. The civil matters are taken up after that. This is point 2. This is Sheriff's case is AR 1954-397. Vivian Bose is known for his jurisprudential excellence as well as articulation, which is par excellence. Please do read it. It will, pausing here for a moment, as you're all students, One of the most oft quoted judges is Justice Krishna here. Interestingly, Justice Krishna here has quoted somebody, and that is Vivian Bose. So therefore, I would urge you to read Sharif's case. Very well written, very well articulated. And this is for the principle that the sessions matters are given priority. Now, the last point is when it Commercial Courts Act and the commercial courts is nothing but fast tracking the litigation in very, very simple terms. Now, in 2 to 3 minutes from now, I'll tell you what is the sum and substance of this Commercial Courts Act. Before that, the third point, I said threefold. The third point is when it comes to litigation such as matrimonial issues, child custody, or for that matter, conventional other litigations, this same, it may not be desirable to fast track it and put a limitation bar. For instance, in commercial courts, you can't file written statement beyond 120 days. 121st day, you lose your right of defense. And the plaintiff has a right to ask for decree. All of you should be aware of that provision. Limitation is based on public law. And at the end of the day, if you look at limitation very carefully, if you say something is barred by limitation, please remind yourselves that the right is not extinguished. Only the remedy is barred. When you say a suit is barred by limitation, the right is not extinguished. Only the remedy is barred. It may not be appropriate to bar the remedy in matrimonial matters, child custody matters, and other conventional litigation. Therefore, the conventional litigation will go on in the regular court as per the Code of Civil Procedure 1908, CPC, as we all refer to it. This is the threefold answer to the question as to why separate commercial courts and the commercial divisions for commercial costs. Now, coming back to this Commercial Courts Act itself, how many of you have had the occasion to read through this act? Can somebody put up your hands? No one? I'm excluding Mr. Rahul Balaji, Kokilavani, Sundareswaran, Karthik Seshadri, Elizabeth, from it's for the others. You've not gone through the Commercial Courts Act? Don't worry, I'm not going to ask you questions. You can be rest assured I'm not going to ask you questions. How many of you have gone through this Commercial Courts Act 2050? It's a very short act. Where act I had, very, very short act. It consists of 23 sections in one schedule. You have not gone through? All right. We will start from there and then try to go into the esoteric level. You may be wondering, what is this Commercial Courts Act 2015? To start with, when you start your lawyering, you may even have some apprehension about going to the commercial court or the commercial division. I'm sure Mr. Shankar Narayan, Karthik Seshadri, Elizabeth, all the other seasoned lawyers, Rahul Balaji, who are all here, will agree with me. I will tell you, it is nothing but an amendment to CPC. It is merely an amending act. Take it from me, it is merely procedural law. If you can conduct a civil suit in the conventional, traditional civil court, if you can conduct a trial You can do it in the commercial court also. You can do it in the commercial divisions in the high courts also. Out of the 25 high courts in India, only 5 high courts have original jurisdiction, namely Madras, Bombay, and Calcutta, which are chartered high courts. And besides that, you have Delhi and Himachal Pradesh. The remaining 20 courts, 20 high courts, do not have original jurisdiction. They are only courts of appeal. So they may not have a commercial division. They will have only a commercial appellate division. But commercial courts will be there in the district courts. Therefore, the difference between a trial of a conventional suit, a traditional suit, if I may use that expression for convenience, and a commercial suit is only the procedure. And as regards the procedure, again, how many of you have an idea about the CPC? Civil Procedure Code 1908, which is somebody is nodding ahead there. Thank you. Thank you. That is the grand norm and bedrock for any trial. CPC. CPC consists of 159 sections, 55 orders, 5 schedules, and 8 appendices, A to H. The orders are in Roman, and the orders are slotted under Schedule 1 of CPC. CPC is the bedrock and grand norm. Out of this 159 sections, 55 orders, and 8 appendices, this Commercial Courts Act amends 3 sections, makes 3 sections inapplicable to commercial suits, amends, which includes the inclusion of a new order, 10 orders, and adds 1 appendix to the existing 8 appendices. There are appendices A to H. It adds appendix I to the existing 8 appendices. That's all. This Commercial Courts Act is nothing but an amendment to the CPC. It is as simple as that. Therefore, what it does is, it is not substantive law. It is procedural law. What it does is, it fast tracks. For instance, I'll give you an example. When a suit is filed, the written statement has to be filed in 30 days and 90 days cap, meaning 120 days for all practical purposes. Beyond the 120 days, the defendant loses his right of defense. Even 1 day delay cannot be condoned. There was some divergent opinions, and ultimately Supreme Court settled in SCG control. It cannot. The plaintiff is entitled to a decree. I'll tell you, similar provision is there in CPC also. You may ask, then what is new? What happened was that provision in CPC, while challenged in the Supreme Court in the Salem Bar Association case, said it is only directory and not mandatory. Therefore, now in a traditional civil suit, even 1,000 days delay in filing written statement is condonable. An application can be entertained. The reason why Supreme Court said it is only directory and not mandatory is there is no consequence provided in CPC. The test is to whether a particular rule is mandatory or merely directory is, if the rule provides for a consequence for breach, it is mandatory. If it does not provide for a consequence, it is only directory in nature. Now, the Commercial Courts Act provides for a consequence. The consequence is the plaintiff is entitled to a decree and you lose your right of defense. This is just an illustration. Therefore, Commercial Courts Act amends 3 sections, makes 3 sections inapplicable and 10 orders. And one of the interesting features of Commercial Courts Act is it has introduced an order, Order 13 capital A, which provides for summary judgments, meaning a judgment without trial, meaning without oral and documentary evidence. If on the pleadings and maybe the plain documents or the documents filed with the written statement, if a court finds that the plaintiff has no real chance of succeeding in the matter, getting a decree, the suit can be dismissed. The plaintiff can be non-suited without oral evidence, without documented evidence. Likewise, if the court is of the opinion that the defendant will not be able to avert a decree, the suit can be decreed without resorting to oral and documentary evidence. Order 13 capital A. It may not be appropriate to do this in child custody matters or matrimonial matters. That is the difference. That is the difference. That is the reason why you have commercial courts for commercial costs. This much about the Commercial Courts Act. And then I will move on to the last part of the topic and try to make it a little interesting. It says role of corporate lawyers. I don't know how many of you are aspiring to be corporate lawyers. I would start on one interesting aspect. What is now very becoming fast growing is AI, artificial intelligence. Tell me, how many of you use artificial intelligence? 1, 2. Wonderful. Wonderful. So then that's made the topic for the day. So that's the topic for the day. All right. Artificial intelligence. Now, pleadings are drafted using artificial intelligence. I am addressing the corporate lawyers to be. I am cautioning you. I will put in caveats. I will put in caveats for you. Now, you all use artificial intelligence. Tell me, what is this artificial intelligence? It's a memorial lecture, but I'm making it andragogic. Pardon me, Mr. Karthik Seshadri and Elizabeth should pardon me for that. I need to make it a little interactive and interesting. What is artificial intelligence? So many of you, so many hands went up. What is artificial intelligence? Can somebody tell me? Please, one of you. Let it not, yes, please. Come, use the mic. Somebody can pass on the mic. Yes, you can be there. Yes, please.
Good afternoon,
Good afternoon. Good afternoon. Yes, please.
So, artificial intelligence is it's from the data set that we have provided. It learns from it. It studies the patterns, and it makes decisions for the situations that we are given. So it does not think on its own. It just studies from the facts or data that we have already given.
Correct. So it does not think on its own, meaning it doesn't have cognition.
That I'm not very sure.
Very sure. All right. Does it have compassion?
No, it will not have. It doesn't have. Maybe
All-
it can mimic compassion by the facts and data that we have provided.
All right.
It can mimic.
All. It can mimic. Mimic what?
This is called compassion. இப்படி இருந்தாதான் empathetic reaction சொல்லி
So therefore, it can mimic the human mind. Right? All right. So which means human mind has cognition. No? Human mind has cognition, compassion. Then why do you say it doesn't have compassion? Human mind has compassion. It mimics human mind. then it should have compassion also.
Its responses can mimic compassionate response. It does not have compassion.
You're very close to the right answer. Very wonderful, wonderful. Any other answer?
Thank you.
Any other answer? All right. Now I will ask you one more question. Permit me to do that. Artificial intelligence is seeing an enormous surge in the recent years. How old is it? How old is it? 5 years? 4 years? 10 years? Wonderful. Yes, yes, please come. Please pass on the mic to the young man there. Yes, please.
Good afternoon, Your Lordship.
Good afternoon. Good afternoon.
Your Lordship, I think it's been there for ages, if I'm not wrong.
Ages.
Ages. And
Ages meaning?
2 decades. I think it started almost in 2000, but it's taken its form absolutely in the past 4 years. A lot of people have started to use it.
Maybe 2 decades.
Approximately.
Any other view? Lawyers should have different views. 19? Wonderful. What happened in 1956? All right. 1956. Yes, because yes and no. Yes, because John McCarthy coined the term artificial intelligence in the convention in Plymouth. So John McCarthy is regarded as the father of artificial intelligence. You're right, 1956 in a way. But do you know which is the first artificial intelligence app? It's nothing but another app. It is nothing but another app. The reason I am spending this much of time because there is a specific part of the topic which talks about role of corporate lawyers, and I find many pleadings being drafted using artificial intelligence and judgments being looked up by resorting to artificial intelligence. I need to make a point. I need to put in a caveat, more than one caveat, but what is the most relevant today? I would like to put in that. Please tell me which. It's nothing but another app. Which was the first John McCarthy coined? Whom would you, if I ask you to say, whom would you regard as a father? I think somebody is saying Alan Turing. Yes. I agree. Not because the person who is answering.
Good afternoon, sorry. May I? Alan Turing introduced the first computational model, and the first computational model's sort of intention or ideology was to replace human effort, which means that any kind of cognition mimicked by machine is artificial learning, and thereby sort of initiated by Alan Turing himself.
Thank you. Alan Turing was a British mathematician. I would credit him as the father of AI. And Alan Turing came up with this test called imitation test, which was used in the Second World War. The German messages were decoded by reversing the whole exercise. Somebody is checking the phone. Please do. Please do, please do, please do. Sorry, pardon me. Excuse me. Pardon me. British. Thank you. Thank you. Excuse me for a moment. He came up with what is known as the imitation test. He was a British mathematician. The Britishers used it to decode the secret messages of Germans. And this imitation test is probably the first artificial intelligence app. Way back in 1939 to 1945, somewhere during, much before 1956. John McCarthy, American, coined the term artificial intelligence. All right. Now, for you to understand, when I was asking about cognition, compassion, I will tell you this. How does basic, I'm not a technocrat. If you ask me whether I am tech savvy, I would, with lot of hesitation, say I'm not tech savvy, but I'm an enthusiastic end user. I describe myself only as an enthusiastic end user. We all started with manual typewriters, with no computers, way back in 1989. No lawyer's office had a computer in Madras for sure. It was much later we had then the black and white monitors, where the computer was used as a typewriter with large memory, and then the evolution happened. That's one part of it. Therefore, I'm only an enthusiastic end user. Therefore, as lawyers, what we need to understand about artificial intelligence, and particularly as if you're aspiring to be a corporate lawyer, how does it work? I will tell you, I have had the privilege of, distinct privilege of discussing it with professors from IIT on platforms where these subjects came up for discussion in the National Judicial Academy. But therefore, without fear of contradiction, I'm saying this, I'm sharing it with you. As the young lady there put it, there's a large data. Data, it's a data mine, which is fed in. One. Two, you have something called algorithms. Algorithm may be a bit too hyper-technical. Algorithm is nothing but pre-programmed set of instructions. And it works on LLM, large language models. Now, when you ask a question as to write a note on Wheeler's case, it, because of the large language model, it can comprehend it as a sentence. And then what happens is this algorithms pound the data. And what it does is, it looks for patterns. It does not think. That is something which you need to understand. It looks for patterns. Therefore, if there is a pattern, if there is a precedent, it spits out the answer. Therefore, it does not think, but it looks for patterns in a large data, and it works on a large language model. For instance, the SEC, one of the most popular law journals, e-law journals. For instance, you want to know what is the whether res judicata is applicable in writ jurisdiction. What do? You key in res judicata and writs and say 10 words, and every judgment of the Supreme Court from 1950, which contains these two terms, writs or writ jurisdiction and res judicata, it will spit out. Some may be relevant, some may be completely irrelevant, some may be partly relevant. Whereas when it works on a LLM, large language model, you can put it in the form of a question. Whether res judicata doctrine is applicable in writ jurisdiction? Question mark. It can comprehend the question and then pound accordingly. The algorithms, which are a set of pre-programmed instructions, pounds the data, looks for patterns, and gives you those judgments where the Supreme Court has dealt with applicability of res judicata in writ jurisdiction. Therefore, do not think you are talking to a machine, or do not think you are talking to another inanimate person, and it is understanding and responding to your query as another human being. It only looks for patterns. Now, coming back to this use of AI, of course, I started by addressing you all as lawyers to be and judges to be. So, as judges to be, use of AI in judicial decision making at the moment is a far cry. I don't want to go into that area. But as lawyers, what is important is you should know how to use the AI app. What is known as cyborg. Cyborg is nothing but part man, part machine. You use the AI, get the input, but then apply your mind. Do your research. Apply your human mind to what it has given you. In effect, it is the computational skill. It can search at a speed which is infinitely faster than the human mind. It can store information which is so much more than the normal human mind. Therefore, the computational skill, computational speed, and the memory, use it, but apply your mind. Cyborg, don't get robotized. In this regard, I'll take another 5 minutes on this and arbitration and conclude. Can we continue on artificial intelligence or should we go to arbitration? Continue. On, I'll tell you how, on the question of how do you use AI, a very, very interesting case. I don't know how many of you have read it. Came up in USA. Loomis versus State. How many of you have read it? I will very briefly tell you what Loomis is. I'll give you the citation. I'll leave the citation with your professor. I think you have a e-library. I had the privilege of being part of the inaugural here. Please read Loomis versus State. 2016, it was rendered by Supreme Court of Wisconsin, not by Supreme Court of America. You know, there are multiple Supreme Courts in America. So it is by Supreme Court of Wisconsin. And Loomis is a case where Eric Loomis was charged with rash driving and plowing into a crowd, shooting, killing about 5 cows. You don't have to go great into the details. That's not of relevance to what we are discussing today. He pleaded guilty with regard to 2 of the lighter charges. He said, yes, I did drive the truck without the authority of the owner. He said, rash, yes, I did, but he denied shooting. The trial went on. Ultimately, he was found guilty. The matter went to the Court of Appeals. What happened was, when it came to sentencing after finding him guilty, the court used, the trial court of the Court of Appeal used a tool, a AI tool called Compass, COMPAS, Correctional Offender Management Alternate Profiling System, Compass. Many articles, pausing here for a moment, I'll just go to language and come back to AI. Many articles refer to this Compass as an acronym. Is it right? Language is not just a medium of communication, but a tool with which lawyers work. Therefore, I'm bringing this up. What is the difference between an acronym and an abbreviation? What is the difference between an acronym and an abbreviation? I said correctional offender. Yes, please. First letter. You can pull out the first letter of an expression and then it becomes an acronym. It cannot be an abbreviation. What are the difference then between an abbreviation and an acronym? Are they synonymous? Why? I'll I'll tell you. An acronym should result in a dictionary word. If it's a dictionary word, it's an acronym. If it does not, if the short form does not result in a dictionary word, it is only an abbreviation. All acronyms are abbreviations, but the reverse is not true. The converse is not true. All abbreviations are not acronyms. It is COMPAS, not COMPASS. It is not COMPASS. The COMPASS is a dictionary word, compass. COMPAS is not a dictionary word. Therefore, compass is an abbreviation and not an acronym. Coming back to this, the court used for sentencing this compass, an AI tool. It is a recidivism tool which is used by prison authorities to ascertain how possible it is for a prison inmate to commit the offense again or be convicted again, those kind of pictures. It's a recidivism tool. They used the recidivism tool and sentenced him. He carried the matter in appeal, and the matter ultimately went to. He wants to be. Please. The matter was carried to the Supreme Court of Wisconsin. One of the arguments of Eric Loomis was the facts are there, the conviction is there, then the sentence is here. Where is the connect? Where is the dispositive reasoning? What is the reasoning that was applied to give this sentence to me for this conviction? He said it is a violation of due process of law. This matter was taken up by the Supreme Court of Wisconsin. He also said there is bias. There is race bias for the data. This is another argument. So on this, facts are there, the sentence is here, but how it was arrived at, the dispositive reasoning, the logic is not there. Therefore, the due process of law stands violated. The best part was, even the court does not know what is the reasoning. For the simple reason, Compass is a proprietary software, not Point INC, now equivalent, part of equivalent now. Then ultimately, the court came to the conclusion that Compass was not the sole parameter. There were several other parameters which were applied for sentencing, and therefore it cannot be said to be wholly incorrect. There, subject to correction, it was Anne who wrote the authored Loomis. The Chief Justice, I'm not able to immediately recollect. He writes a concurring opinion. He writes very nicely. What is of relevance to what we are discussing today is, he says, I concur with the conclusion, but I have some reservation on the judgment penned, where the terms consider and rely are being used synonymously. He said they are not synonymous. Consider, but don't rely. This is what he ultimately wrote. That is the message I would like to give you. This is the reason why I want you to read Loomis. When you use AI app, consider, but don't rely. That's very, very important for corporate lawyers to be. And I'll just conclude with two sentences on arbitration. On arbitration, It is a ADR, alternate dispute resolution, one of the mechanisms. Mediation is another. Now, mediation is built into the Commercial Courts Act under 12 capital A. What is the difference between arbitration and mediation? Both are ADR. Why have two different systems? In arbitration, there is adjudication. In mediation, there is no adjudication. Both parties sit across the table, give up some parts of their respective claims, and they arrive at a common plane, and that is made a conclusive binding order between the parties. Whereas in arbitration, there is adjudication. Once an arbitration happens and an award is passed, that can be challenged in a court under Section 34 of the Arbitration and Conciliation Act 1996. When it is challenged in a court of law by virtue of Section 10 of the Arbitration Act read with the Commercial Courts Act, it will go to the Commercial Court or the Commercial Division. This Section 34, as corporate lawyers to be, or anyone who gets to deal with arbitration, should bear in mind, is not an appeal against the award. If you treat it as an appeal against the award, the whole concept of ADR, the whole system of arbitration will collapse. It is not an appeal. It is not a revision. It is not a full-fledged review. Then what is it? It is a mere challenge to the award on 8 grounds set out in Section 34. As Mr. Karthik was mentioning, I refer to it as pigeonholes, 8 pigeonholes. If a protagonist of a Section 34 petition who is laying a challenge to an arbitration award is able to demonstrate that his or her challenge to the award fits, not just fits snugly into any one of the pigeonholes, the award is dislodged. If it doesn't, the award is sustained, even if it is a mere error in law. Please bear that in mind. In an appeal, a judgment suffering from the vice of error in law will never pass muster. If it is a regular appeal under Section 96 of CPC, but under Section 34 of the Arbitration and Conciliation Act, if it is a mere error in law, even a patent illegality will pass muster. Do not forget about that. Make these fine distinctions very clear. Have these fine distinctions very clear in your mind. Now, before I conclude, there is one other aspect which I thought I will touch upon. One of the important aspects of this Commercial Courts Act is it provides for a pre-suit mediation, meaning pre-institution mediation under Section 12, capital A. Section 12, capital A is a standalone section slotted under Chapter 3, Roman 3, capital A of the Commercial Courts Act. What it says is, before filing a suit, if no urgent interim relief is required, the parties should resort to mediation. And only if the mediation fails, you can come to court. Therefore, resorting to mediation is made a condition precedent for filing a suit. There were divergent opinions as to whether this is mandatory or directory. Ultimately, in Patil automation, Supreme Court confirmed that it is mandatory. And then in Yamini Manohar, the Supreme Court, in paragraph 10 of Yamini Manohar, Supreme Court said the court would test whether there is urgent interim relief necessary. And the Vardhan, which Sri Karthik was mentioning, what is urgent interim relief has been explained. I think subject to correction that continues to hold the field. This is one aspect of it. Now, when you resort to mediation, you come to a conclusion. Is it enforceable as a decree of the court? I have a claim. Let's say I have a claim for 1 crore against B. Both of us, and B has a set off claim of 50 lakhs against me. So then we sit across the table. We say that, all right, I'll scale down my 1 crore claim. He says, all right, I will scale down my 50 lakhs.
Very much.
many arbitration clauses have that, most particularly in infrastructure contracts and many of the state contracts you will have.
Thank you, Maharaj.
Arbitration itself can be avoided.
In interim,
Sorry? Yes, before arbitration. What you refer to as PR.
yeah.
Correct. You're right.
Lordship, I have
Yes, yes.
Good afternoon, Lordship. Thank you.
Sorry, so your mic is.
Thank you so much for the full lecture.
No, but find out whether somebody has got any other question.
Does anyone else have a
Please feel free to. Considering where I'm sitting with me, notes, I'll try to answer whatever is permissible. But whatever is permissible, whatever is permissible.
Good afternoon, Your Lordship. That was a scintillating lecture we had. Really, it was an interesting lecture, sir. I have two questions for you, sir. One pertains to point of how foreign courts have a perception of Indian courts and how that is a relationship of convenience. And often we see that foreign courts want to have the cake and eat it. So when foreign litigants sue Indian companies, and they often take this bogey that Indian commercial disputes matter prolonged for a substantial duration, hence want the preferred choice of forum being the foreign courts. And when Indians sue at jurisdictions, take the Bhopal gas tragedy as a typical example, foreign courts conveniently say that Indian courts are the most appropriate forum. So how do Indian courts respond to this sort of perception, particularly when Indian advocates and Indian retired judges also depose on the poor state of affairs in the Indian judiciary in foreign courts or forums of expert perspectives? So that was one point. The second pertaining to art legends, Your Lordship. I feel that somewhere artificial intelligence becomes a slippery slope. You very rightly pointed out about how there's a difference between considering relying. I take the example of our academic position where we have this plagiarism checks, Your Lordship. So that was put an example of technology aiding human oversight, but now blindly editors in journals, they don't apply their mind when terms such as Ambedkar Law University's flag, that also becomes a basis for rejecting articles. So I feel somewhere artificial intelligence will become a calculator rather than an assisting tool where you say the math has to be right. So I, as a judge, will go in for it, and I will not I may say that it is only. So I know I've put a lot, but it's your Lordship.
Question as regards on the time taken, cost of benefits, it will all flag in a white paper by now. That was one of the reasons why the Law Commission made this recommendation. This white paper was one of the parameters which led to the commercial courts between here at that point of time was ranked below 100. I don't remember it was 158 or something in enforcement of contract, cost of enforcement and time. So that is one of the reasons. Thereafter, there has been right fights. We have climbed up the ladder very quickly. Now we are fairly high in the ladder now. So therefore, that is contribution of the commercial courts, commercial division. And that white paper was one of the reasons. That's part one of your, that's the first question. And the second part as regards artificial intelligence, the answer is what I said, cyborg. Part machine, part man. The computational strength and the ability cognition of the human mind blend together, and that is cyborg. Need to function as a cyborg, and definitely helps in terms of computational speed, finding the results very quickly, because you may not use digests to find case laws. So therefore, you may not be able to appreciate that to find out one case law for a case which is to be argued. 3 juniors will sit in the library for 2 days, pull out the digest, and then take out the case laws on that subject and then shortlist it, see which is in your favor, which is against, and also see which has been overruled. You won't readily know which has been overruled. Now, all this you get with a flick of the finger. But only thing is, don't go to the dispositive reasoning directly. Look at the number of man hours required. Those days we put in. Pre-juniors, 2 days. Assuming we spent about 12 hours and worked for about 6 hours. I'm consciously using the two expressions. Still, look at the number of man hours. So all that one flick of the finger, you know all the judgments from 1950 to date, and you know which has been overruled. Those judgments which have been overruled or distinguished are also there. You get it in no time. So there it does help. But the question is, you should know how to use it. Don't rely completely. Apply, consider, but don't rely. These technological, it's an excellent search engine, but it is not a substitute for your. That is how I would. Yes.
Lawyers
Yes.
at this lecture. The first one being your lordship, that has the rise of arbitration genuinely reduced delays in commercial dispute resolution, or has it merely replicated the inefficiencies of traditional litigation in a private forum?
From a lawyer, I normally put questions. Today it is the reverse. I can broadly figure out where it emanated from. Which part of the arbitration, I would not say has either been a complete solution or neither would I say that it has not served its purpose. You get a dedicated judge applying his or her mind. You get a dedicated tribunal which hears the matter. And if the arbitration fixes a particular date and time, you know that the matter is going to be taken up and it is not dependent on another matter before you. It does have huge advantages. And I think probably some delays might have happened because of the application of Section 34. If Section 34 and 37 are rightly applied, I'm sure it has definitely contributed to accelerating the resolution of commercials. You can't say that it has not fun. May have certain short flaws. So we may have to put in place a system. I mean, make it more efficient. Is efficient? We may have to make it more efficient. That's my answer.
I would like to trouble you with one more question.
Please, please, it's not a trouble. It's a pleasure.
Your Lordship, the second question deals with regard to the cost of justice. So the question is, with arbitration and high stakes commercial litigation becoming increasingly expensive, are we witnessing the emergence of a system where effective dispute resolution is accessible only to well-wishing parties?
That is why commercial law as such, I wanted to start with that, but other than they went impromptu. Commercial dispute is defined. For instance, if you take some definitions in the Arbitration Act 2 and F, International Commercial Arbitration, we'll talk about legal relationships between two parties, whether contractual or not, considered to be commercial in obtaining law in India. Likewise, Section 44. Is there any law which says which is a commercial contract? What is commercial? There is none. There is none. You have to only go to case law jurisprudence. I can give you the case laws, read it. Money engineering. 1963 SEC online. Bombay 82. Desai's judgment. I'll just tell you the uh, relevant portion on that. He writes, it is difficult to find the exact meaning of the phrase matters considered as commercial under the law in force in India, quote and unquote. Neither side has been able to point out any particular law wherein the phrases commercial or matters commercial have been defined. I apprehend that the intent of the legislature while using the above phrase was that in matters of commercial contracts, foreign arbitrations and awards should be recognized and enforced. It goes on like there are several other judgments. RM investment versus Boeing, another judgment. 1994 4 SEC 541 RM investment. There, if you go to say paragraph 14, there it says while construing the expression commercial relationship, what it means. Commercial, what is considered commercial in obtaining law in India is not defined anywhere. It is not explained anywhere. It is not codified. You have to only look for judge-made law. And basically, if you see, it talks about profit. If it talks about profit, I think the question stands answered.
Last question. Is your
It's not so much a question, but something that I wanted to request your thoughts because you have been a busy practitioner, practiced in various high courts, and you are in the midst of students. Ask what students of a law school who are now on the cusp of becoming lawyers, what is the approach that they should adopt? Transform them because we are here transformation of commercial distribution. Corporate. What is it that we require? Students required to transform themselves. Students to successfully lawyers, what their aim should be, what their training should be in the initial years, how they work. And on the dangers of AI, I wanted to point out, even on the stage at the banner that has been put up, it is clearly generated by AI. Because what Justice Sundar there is and what Justice Bharti Das is there.
I saw that.
It is what AI wants them to be, but it is really not there.
I saw that.
So
I saw that.
That is clearly what one of the dangers of AI. And I think that is also, I mean, how we use it as a tool and how we train it, that is also the important youngster in terms of what their approach to using AI.
It's a very pertinent question, but I would respectfully say it calls for another lecture. It's I don't want to eat into your lunch. Pun intended. I don't want to eat into your lunch, but then I'll just try to very briefly tell you. See, transformation by itself. See the dictionary meaning of transformation. Transformation, if you see the dictionary, some of the established dictionaries, it will say complete change of character for betterment and improvement. That would be broadly the definition of all dictionaries. So therefore, expression transformation itself presupposes complete change of character for betterment and improvement. That is very, very imperative for becoming a lawyer. And you should probably recognize the difference between becoming a law graduate and a lawyer. There is a world of difference between the two.
That note, thank you so much, Your Lordship, for that deeply illuminating address. Your Lordship's exposition of the statutory framework, the institutional mechanisms, and the evolving jurisprudence on corporate law has not only clarified for all of us the law as it stands, but has also enriched our understanding on the principles that animate it. And I think I speak for everyone in the audience when I say talking heavily and deeply relying on the insights that we've gathered from your lecture, your lordships, and keep using them hopefully in our careers ahead. On that note, we move on to this certificate distribution ceremony to honor our judges, winners, and the top rankers of the C. Harikrishnan Memorial Essay Writing Competition. I now request Ms. Fatma Al-Zahra, the student coordinator of this program, to kindly announce the award.
Good afternoon, everyone. May I now request our esteemed judges of the C. Harikrishnan Memorial Essay Competition to kindly come forward as we felicitate them for their invaluable contribution. May I invite Rajiv Raj Mohan, advocate at the Madras High Court, to come up on the stage. Thank you, sir. I request Justice M. Sundar to do the honors. May I invite Nita Mary Matthew, Faculty Corporate Law Department, SRM University, to come up on the stage. May I invite Nisha Shri S., former president of the Moot Court Association. Could we please have Justice Basha and Justice Sanjay to please come up on the stage? And now the moment we've all been waiting for, the announcement of the winners. This year, the competition witnessed exceptional participation, and we have at third prize, rupees 10,000. I am pleased to announce the third prize goes to Subiksha. May I request you to please come forward and receive the award. Next, the second prize with the cash award of rupees 15,000 to Ashwath Dinakaran. And finally, the first prize with the cash award of rupees 25,000 to Sharavind R. In addition to our prize winners, we would also like to recognize our top performing participants who will be receiving certificates and mementos. I will now read out your names. As your name is called, please come forward. Kavya VK. We request all the participants who are present here to please stand in line. Yes. On behalf of Kavya VK, we have a representative collecting the award. Next, we have Limulua Mary J. We request Elizabeth ma'am to please come up on the stage. Next, Chitra. Aparna N. Madhumita S. Rahul D. Karthikeyan S. Karthikeyan S. Shri Gayatri R. Vijay Karan. Satya Priya B. Shobini D. Yubinesh Babu G. Kayal Willi. Divya Karasi. Bhakya Shri M. Kavya B. And finally, J. Mariam Sumaya. Can we have a huge round of applause for all the participants? Before we conclude, I would also like to acknowledge the incredible efforts of our student coordinators. May I request the following coordinators to kindly come forward. Mariam, Nivedita, Monica P, Mohammad Ziaur Rahman, Surender S, Anjali, P. Gayatri, Nidarshana, Vaishnavi, Bhargavi, Arun Kumar, Hari Rupan, and Fatma. We have a huge round of applause for the student coordinators.
Thank you. And all our different awards. May I now please call upon Mr. Ashwath Dinakaran, one of the winners of the essay writing competition, to please share a few words about his experience writing his essay and participating in the competition.
Dear Lordships, dignitaries on and off the dais, my dearest professors, spectators of this event, Vanakkam. At the outset, I think I'd be failing my duty if I do not really mention how grateful I am to Mr. Karthik Seshadri sir and Mrs. Elizabeth Seshadri ma'am for having put up this wonderful event and even conducting this competition at the first place. And to be honest, it's been such a stupendous opportunity. And the reason why I call it stupendous is for two reasons, basically. Number one, the fact that we were able to hear Justice M. Sundar himself on a Saturday morning, and that too on a very, on an absolutely carefully drafted topic by itself. And especially him talking about artificial intelligence and interacting with us really made it a lot meaningful. Thank you so much, Your Lordship. That said, secondly, and ultimately, it is not any day that a 21-year-old, a 20-year-old, and a 19-year-old would sit on a panel here and discuss about shareholder primacy and stakeholder capitalism. And that opportunity, the fact that they were people, those who have been wearing black robes and neckbands and interpreting these provisions on a day-to-day manner, these people were listening to us talk about how we interpret the provisions. And I think that's an opportunity which I'm forever grateful to Mrs. Iron Thomas for giving us. Thank you so much for such a wonderful opportunity. That said, to serve my purpose, I'd want to briefly reflect on all the one figure of the company that is what my data was focused. But about what it was an exercise to see the law for what it is, what it can become. Once again, I thank Mrs. Iron Thomas for curating such a nuanced and relevant theme and for giving us a platform to engage with it so meaningfully. I'd end it with this note. If only I'm being given the capability to write my company law paper again, I'm sure I'd be able to score what I scored earlier. Thank you so much.
Thank you, Ashwath. As we now approach the conclusion of this memorable gathering, it is now my privilege to invite Senior Advocate R. Shankaran Narayanan Sir, who also formerly served as the Additional Solicitor General, Government of India, to please deliver the vote of thanks.
Good morning. Thank Honorable Chief Justice Manipur, Dr. Jensen, for having accepted the delivery. When Karthik Seshadri told me that he would be delivering, I said that there is one comparison to take. So Harikrishnan had the habit of going with the historical perspective. Another 55 at that time, another 11, when it came to the 58, 59, he went to the historical perspective. As a lecturer of Madras Law College, we were not disappointed. We had a great anatomical dissection of three different pieces of, as a surgeon would do, and tell us the comparative aspects and the way in which each interacts with the others and the result. For a moment, I'm sure Rahul Balaji, Suresh, and all will agree with me. We felt as though we were an either phone problem 3 or I also recall the conference we had in Arbitration, where the date of amendment of the application thereof by the Supreme Court or non-application thereof, commented by your lordships to that conference. We found that how the date of notification was very important. Sir, it is really a pleasure that you took time, came all the way from Manipur to be with us and made us feel that we are again in the classroom. It was to me a wonderful lesson. I belong to a generation which believed in deforestation, because they still go by papers. So AI, computer, everything meant a lot to me, and I really understood. Honorable Dasan, he is not here today. Right now, he has left because he has got other engagements. Today, sir, I am going on in Chennai. 4 months going on. Therefore, I can understand many who are absent who are present. I thank him. I thank Justice Basha for having come here and treated all along. Sir, I know this admiration for C. Harikrishnan. Mr. Kumar, we thank you very much for him. I must say that the work is complex. Maria, you did extremely well. And I was in the interaction session. The boys who won the prize, I saw one talking with confidence, one talking with absolute whatever they wanted to be precise. It was quite interesting. And I find that all of you are definitely the materials to be, lawyers to be, judges to be tomorrow. And Professor Ranjit, who I have a long association, one of my professional junior colleagues, Harshini, introduced me at the long ago. I have not been in touch with him. I know that he prepares the students for. It's really wonderful. I thank this university for having hosted this function. As an ardent admirer of C. Harikrishnan, on the side, I just can't. You're so ridiculous. Definitely, I take it as an opportunity that a man of that stature, he remembered, recollected, you all live in this memory. As a person who had been right from my college days, when I used to visit him, not as my lecturer, but as a lecturer in a different class, he would always clarify all doubts. So kind to me, so that I used to tell people, probably I was the same as knows. It's really a wonderful session, even though it is quite late, all of you are sitting and weak. I am 100% sure. When you go, not only they say that you lunch with Plato and dine with Aristotle, you have done it with Justice Sundar today. Thank you. Jai Hind, Vande Mataram.
Thank you so much, sir. You're very, very kind, sir. No event is complete without a vote to the country we all pledge our allegiance to. May I request everyone to please rise for the national anthem. With that, we come to the conclusion of our occasion today. I thank everyone again, all our members of the judiciary, the bar, the students for being here today. As we disperse, we carry with us not just the memory of this event, but the ideas it has set us in motion. I hope everyone has a wonderful day ahead. To all the audience members present here,
there is lunch arranged. We kindly request everyone to please have your lunch and leave. Thank you so much. Have a great day.